Marijuana is still illegal in North Carolina, and if you get caught with it, you can face probation or go to prison. We're going to break down what happens if you get busted with marijuana. I'm Sean P. Keenan, a North Carolina criminal defense attorney who practices in Lenoir, Greene, and Jones counties. In this video, I'm going to guide you through what happens in North Carolina when someone gets busted with marijuana. We're first going to break down what North Carolina law says about possessing marijuana. If you're caught with under 1/2 ounce, you would be charged with simple possession, which is a class 3 misdemeanor, and can bring up to 20 days in the county jail. If you are caught with up to 1.5 ounces, you could be charged with possession, which is a class 1 misdemeanor. That can land you in the county jail for up to 120 days. If you're caught with more than 1.5 ounces, you could be charged with a class I felony. That can come with up to 24 months in the state prison. The marijuana laws in North Carolina can be very strict, and depending on how much you're caught with in your past criminal record, you're going to need to create a defense. One way to resolve the matter is you could cooperate fully and plead guilty. The pros to this are you're less likely to get an active jail sentence, or if you do get an active sentence, it could be significantly shorter. The cons, however, are that you will be convicted of a misdemeanor or a felony, and that'll be on your record. It can affect sentencing later on if you're ever convicted of a misdemeanor or felony again. Additionally, if you have a felony conviction, you can never possess or even be around a firearm again. You could plead not guilty and take the case to trial. The pros to this are you could be found not guilty because you're either in fact not guilty or the state violated your rights in some way during the process. The cons, however, are you could be found guilty and get an active jail sentence or a prison sentence, where if you pled, you might only get probation. Trials often bring a great deal of uncertainty, whereas a plea will bring more certainty. People ask me, should I get a court-appointed attorney or should I retain a lawyer? Well, there are pros and cons to both. The pros to a court-appointed attorney are it costs a lot less and you only pay if you're convicted, or sometimes the court will make the payments a civil judgment. That means if you get a state tax return or win the lottery, the payment will come out of that. The cons, however, are you don't get to pick your attorney. I won't say that a court-appointed attorney won't work as hard for you, but oftentimes some attorneys are less experienced in certain areas of the law, and you may end up with an attorney who doesn't have the necessary experience to handle your case specifically. You can hire a private attorney, and the pros to this are you get to choose who represents you, and you can make sure that you retain an experienced attorney who has time to dedicate to your case and represent you the best way possible. The cons are you have to pay your attorney, and it can be expensive, but it is worth it. I recently represented a client who was charged with open container of wine or liquor, misdemeanor simple possession, misdemeanor possession of marijuana paraphernalia, and speeding. Through planning a well-crafted defense and a little bit of work on her part, I was able to get all of the charges dismissed. Not all cases end in a full dismissal, but with the right legal defense, many can end that way, or at least limit the impact that the case has on your life. I create videos like this to help people navigate the criminal justice system and not get lost in the mess that it is. Also, if you or someone you know has been charged with a crime, contact my office, schedule a consult, and we'll spend 30 minutes going through your situation to determine what you can do about it. I'm Sean P. Keenan, and your case is my mission. Get a Marine to fight for you.